Wait a minute. একটা অরিজিনাল সাইডে কবে রাখবো?
May I have a lordship's leave to mention on the order side review matter, my lord. Well, there's some emergency, my lord.
We'll sit on Tuesday, don't worry, give.
May I have my lord's kind leave to mention order 41 for admission. Admission under order 41.
Always, give.
But one more matter, may I have your lordship's kind leave to mention my lord, item number 210. It is a contempt matter. My lord,
We'll take up contempt one day, don't worry.
My lord, may I be permitted to mention, my lord, what happened, my lord? Yesterday, my lord, this matter was appearing as item number 4, my lord. I tried to, my lord, join by VC, my lord. I was not allowed, my lord.
No, it can't be.
My lord, it happened, my lord. Yesterday, my lord, my clerk also came, requested, my lord, but it somehow.
কেন করেনি ভাই কালকে ভার্চুয়াল মোডে?
বলছেন কালকে ভার্চুয়াল মোডে ছিল বলছেন?
আমি ছিলাম কালকে ভার্চুয়াল মোডে, আপনি অ্যালাউ করেননি আমাকে। আমার ক্লার্ক এসেছিল কালকে সকালে আপনাকে বলতে, আইটেম নাম্বার দিয়ে আমার জুনিয়র করেছে। আমি 3টে ডিভাইস থেকে। My lord, what is happening? This webinar system is creating a havoc, my lord. Now, my lord, this, my lord, in Apple, my lord, in webinar system, I don't get any window to, my lord, put my name and, my lord, petitioner or, my lord, in the other devices, my lord, I tried, my lord, my junior, my lord, who is the advocate on record in the matter, my lord.
We are working with a particular software. So
my lord, I understand.
have to download that
My lord,
software.
kindly, my lord, for correction, my lord. It was for correction, my lord.
My lord, may I be permitted to mention for inclusion of group 2 application?
Application transfer.
Yesterday, my lord has decided when one that contempt application is
Yes. কালকে কারেকশনে ছিল, উনি বললেন যে আমি ওয়েবসাইটে ঢোকার চেষ্টা করলাম, সেটা দিল না আমাকে পারমিশন, এটা বলছে। Yes.
For judgment, item number 1.
Time for the appeal.
For the board, my lord, led by Quilly Bhattacharya.
Appeal allowed, order set aside.
Extremely big.
Direction is given. Will reconsider.
Yes, next.
Item number 2.
Time for the appeal.
For the board, my lord.
Appeal allowed, order set aside. Direction is given to reconsider the application.
Yes.
Item number 3.
I am for the appellant, my lord. That matter, my lord.
I have read it. দিয়ে দাও, আমি ডিক্টেট করে দেব।
চেম্বারে দিয়ে দিতে হবে। Item number 11. Item number 11.
Item number 11, Mr. Sukumar Bhattacharya appearing for the Union of India. Respondent. Now, should kindly give a short pass over his comment.
Where is the appellant? Pass over anyhow.
Item number 13.
My lord, Mr. Debashish Saha is appearing for the appellant. He is in court number 33 on his legs, my lord. I'm praying for a short pass over.
Next.
Item number 14. Item number 15. Item number
14, my lord.
15.
14 appearing for the respondents, my lord.
Where is the appellant?
15.
But 11, my lord, I appear for the respondent. I think, my lord, this matter should not be before your lordships, this bench, because this is a railway claim case. Should go before the
first appeal.
First
appeal.
No, the railway claim case is now it is taken up by and the appellate side rules of the session.
We'll have to see that. 16.
16.
My lord, I am for the appellant, my lord, in this matter. Learned Advocate Bishop Vishwarup Bhattacharya is appearing. Lord, I'm praying for not today, my lord, but all short passover, my lord. He's on legs before 4:19. Passover.
Yes. 17. 18.
I'm appearing for the appellant, my lord. I mean, less than a Thakkar. I'm praying for a short passover, my lord.
Yes, yes.
20. 22. 25. 26.
26, my lord, I am for the state in this matter.
Yes. What can be done? Can we dismiss?
No, my lord.
Passover, next.
Okay, my lord.
27. 28. 29.
No, I'm for the state.
What can be done? Next.
31.
I'm appearing for the appellants, my lord, led by Mr. Atrup Banerjee.
31.
Yes, my lord, I appear on behalf of the appellant.
What is the
My lord, 31.
what is the defect?
My lord, defect is a formal one. My lord, it can be removed here and now because the typographical error is there in respect of
see.
4 names. That is to be expunged. Achha, no, defect. And there is a delay of 7 days. My lord, I have.
Have you served?
Yes, my lord, it has been served. My lord, this is the affidavit of service.
কালকে খুব বাজে টাইপ করেছো।
But the order in the under appeal, my lord, if you lord.
Just 1 minute.
My lord.
চেম্বারে রেখে দাও চেম্বারে ব্যাপার চেম্বারে রেখে ভালো করে বের করে নোট দিয়ে দিতে দাও মার্কিং করে নিতে
My lord,
Why you are aggrieved?
my lord, aggrieved part is my lord.
Nothing or aggrieved parts. There was already a direction for conducting the inquiry.
My lord, this
the
order
inquiry-
was passed by the authority. My lord, on 3rd
There was
September.
nothing. It simply says inquiry was to be conducted and the report should be filed before the board. Now the board will take a decision.
My lord, the issue remains, if your lordship kindly come to the latter part.
Embezzlement of the funds, so far as this
My lord,
school funds is concerned, the board will take a steps.
but till today, my lord, the issue remains.
That is what is you can't usurp that the court will make an inquiry.
No, my lord, I am not on that. My lord, there ought to have been a positive direction to that effect.
Yes.
That is
Where
required.
is the other side?
My lord, I have served.
My lord, I am for the respondent. I'm praying for a short pass.
No passover.
But only
Where
modification
is
this part.
My senior is engaged in another court.
sorry, where is he? Who is the gentleman?
Court number 38. Your
Who
lordship.
is the gentleman?
Mr. Shonu Ghosh.
Sorry, Mr. Tapan Kumar Mukherjee is here. He was here. We are permitting him to appear. ইনকোয়ারি করার জন্য বলেছি কিন্তু কোনো ডিরেকশন নেই This is the small matter which can be modified. Who appears for the state? Others?
Bhaskar Prasad Vaishya.
That is, he's for the DPSC.
My lord. My lord.
He's for the state. Sorry.
State.
Where is Mr. Tapan Kumar Mukherjee? Can you not get hold of him?
তপন কুমার মুখার্জি
এই এখানে তো বলেছি তোলা
এক্ষুনি ছিল
He was there.
Or can you contact Mr. Bhaskar Vaishya?
So I can.
Please contact him. 5 minutes. If he does not come, then we will.
সাইড করো এটা।
Small matter, unnecessarily adjournments. Call the next.
32.
My lord, 32. I'm kindly playing for a short pass over, my lord.
Next.
33.
My lord, in item number 33, my lord, Mr. Orpo Chakraborty is appearing on 33, my lord. Mr. Orpo Chakraborty is appearing on behalf of the appellant, my lord. Has not come to the court today, my lord.
Not today. Next.
Great.
34.
Playing for short pass over.
Next.
35.
35, I'm for secondary board, your lordship.
Next.
36. 37. 38. 39. 41. 42. 45. 46. 47.
47, my lord, I'm for the appellant, my lord, I'm led by Mr. Colonel Basu. And I'm praying for a short pass over, my lord.
What is the defect?
Defect is, my lord, that delay, my lord. I have preferred
Have
a
you
review.
served the copy?
Yes, my lord, sir.
Where is the service?
Yes, my lord. This is affidavit of service, my lord. My lord, a review was preferred, my lord. For that reason, I could not file the appeal within that time. That plea has been taken, my lord.
Who is for the state?
My lord, I have served the government pleader's office, my lord. I do not know who is
When
appealing.
it is served?
My lord, it is served before the office of the GP
23/7.
on, my lord, 23rd July 2024. My lord, may I come back on Monday, my lord, and ascertain who is appealing for this?
Hear them. Score lovely. Next.
Grateful.
এখানে ধরে 48. 48. 49 and 50.
My lord, 49 and 50, I'm being led by Mr. Anirban Ray. My lord, I had mentioned the matter yesterday for extension of the interim order.
So today we are disposing of the matter.
My lord, in that case,
Who is the advocate on record? Where is Mr. Piyush Agarwal?
my lord, I am Mr. Piyush Agarwal's junior, my lord.
Yes, so you'll have to argue.
My lord, then in that case, kindly grant a short passover, my lord. Mr. Ray was submitting before your lordships.
Next.
51. 52. 53. 55. 56. 57.
7, I'm for secondary board, your lordship.
58.
My lord, 58, I am for the School Service Commission. Hey, তুমি আছো?
Lord, in item number 58, my lord, Mr. Ujjwal Rai is appearing on behalf of the appellants, my lord.
58.
58, my lord.
58, my lord, board is an essential party, has made a party respondent, but your lordship copy not served.
Lord, I'll just serve then, my lord. Lord, kindly, my lord, passes it over, my lord.
Pass over.
এই চলে এসো। চলো।
এই, copy দিস না, board কে copy service করিস নি?
What is service line?
না।
My lord, let me not to do one for this one.
Not today. Make a next second call.
Second call.
Item number 11.
ফাইলটা দাও।
সেকেন্ড কপি আছে
None appears in support of the the appellant. The appeal is dismissed. Sorry, applications are dismissed for default.
My lord, yeah, I have been, my lord, instructed to address to your lordship, my lord. Item number 11, Miss Banerjee, my lord, is appearing, my lord. She is indisposed today, my lord, could not come to your lordship.
Where this is second call, where he was in the first call.
But she could not come, my lord.
Where this prayer was not made in the first call.
But that I cannot, my lord, assist your lordship because this is the clerk, my lord, who has.
I understand. Then why this clerk did not instruct you in the first call?
My lord.
Not today.
Grateful, my lord. I'm sorry, my lord. Grateful, your lord.
Next.
13.
I'm for the appellant.
13 টা বার করে তো 462 2020
So many, I think 10 applications.
My lord.
Pilot, our matter was item number 11, Passover matter. We are sitting here.
Nobody responded. So what can be done?
We heard my lord, second call. First call
Second
is
call, item number 11 was called. Somebody was here. Says that the I think the learned lawyer who is indisposed.
We are sitting here, Pilot.
What can be done? You did not hear. Next. Must be gossiping between you and what can be done. So involved in the gossip, then paying attention to the court. Yes, next.
13.
I'm for the appellant.
I am for the respondent number 18 to 24. One after another, please show us those applications. We will take up all the applications. We are not going to dispose of the main matter.
Right.
Tell us, first one is Can 1 of 2020. What is this application? The applications গুলো বার করে তো একটা সিরিয়ালি রাখা উচিত। এত বড় ফাইল দিয়ে চুকে অ্যাপ্লিকেশন গুলো বার করে দাও, তাও এটাও নাও।
ওইটা তো সাহেবেরটা।
এই দাও। Urgent hearing of the matter. Then can do taking.
Not for interim order, my lord.
Why the judgment include be not set aside on an application?
Is a change brief. In fact, some of the applications have also not
You
come
have
down to me.
inherited the asset, then you must inherit the liability as well.
Yes, my lord.
So inherit the liability.
That is
Respond.
that is true, my lord.
And then you wanted this memo of 2019 to be stayed.
May of 2019, my lord. 23rd December to 2019.
The writ was of which year, or the mandamus appeal was of which year? 2020.
2020, my lord.
And what was the date of the order of the trial court?
The trial court's orders, my lord,
24th of February
24th of
2020.
February 2020.
So why this memo of 23/12/2019 was challenged?
My lord, it was challenged in the writ petition.
Petition
No,
dismissed.
interim order was refused.
Against that, this appeal
Against
from
that,
2020 is
yes,
there.
my lord.
Then next, third application. Oh, you wanted the court to fix the date and then proceed. Third application.
Done.
I think your client has lot of solvency.
No, my lord, this is an association, and my lord knows in an association there are different types of
Collecting
persons.
money.
There are different types of
Collecting money
persons with
and
different
burning-
opinions.
And burning on you is good for the
No.
for the bar. It's very good for the bar. These applications I never come across over there.
My lord.
That hear out the appeal on a date 1/7/2020. You hear
Difficulty
out,
is, my lord, may
and then
I indicate one thing, my lord? The difficulties of this with this matter is this,
what is this 93 days delay? What is this?
that it has been condoned, my lord. The delay has been condoned.
Then why this appeal is a application disposed of?
My lord, kindly sees the order at page 246 of the paper.
Sorry, let us see applications. Let me see how far
The problem is
members
this,
of
my
the
lord.
bar can go. That is
What
I'm,
happened, my lord? May I indicate this? Why this happened?
Application for condonation of delay in preferring for condonation and for hearing on 1/7/2020. Why second application for condonation? Why second application for condonation? Can 3584?
No, 3584 is not filed by us, my lord.
Not filed by you?
No. 3584, my lord. My lord, kindly check. 3584.
Applicant. You are the applicant, sorry.
কি করবে? ফাইলে রাখতে হবে তো। It is filed by us, my lord. 3584.
Your
Yes.
second condonation.
Yes, second condonation.
Very interesting.
Allow the application.
Let us see. Then
it is for the early disposal of the application of condonation of delay.
The prayer.
My lord.
So 4168.
Well, ultimately it has been condoned. Delay has been condoned.
Whatever. 4168.
416.
Addition of respondent. Who? Who are the applicants?
দেখি 4168 এখানে আছে। Yes. এটা নিয়ে দেখুন 4168, my lord. এটা তো আমার
It's addition.
আমরা সবাই এখান থেকে
রেকর্ডটা দেখা বলবে এওআর কে আছে দেখো আমি আছি কি
সন্দীপ কুমার কুন্ডু
না তাহলে এটা আমার
হয়ে গেছে। অ্যাপ্লিকেশন গুলো সব দর্শক দেখতে দিয়েছেন সব এগুলো রাখতে হবে করে এগুলো একসঙ্গে রাখো 33 হ্যাঁ চলে যাও হ্যাঁ হ্যাঁ একা আছো
What is this can 1047 and 1814? Who are the applicants? Was this a addition of party?
1047 and 1047, my lord.
And 1814 by the impugned order, these two applications are disposed of with a direction to amend the cost title of the memorandum, the writ petition. That means must be an addition.
My lord, one
Addition of
application
parties.
was filed by us for addition of parties.
Which one?
My lord, that number, my lord, I am very sorry, my lord, I cannot recall. But one was by us and the other application by another group of, my lord, teachers.
Here also I find one addition application. I just wanted to know whether these applicants have filed the addition application or somebody else.
No, my lord, these applicants, the appellants not. My lord, some persons who are claiming that they are the guest lecturers and they will be affected if this writ petition is allowed, they have filed this application, my lord.
Lord, 18 to 24, they have been added as respondents, my lord, pursuant to, my lord, I am representing them, and that was pursuant to.
I understand.
Right.
When an addition application is filed, must
Right.
be from a third party to the writ petition. That has been allowed, but I find there is another application for addition filed in the instant appeal.
In the instant.
I just wanted to inquire whether these applicants are the applicants of those applications.
My lord,
which
my
have
lord,
been
my lord.
allowed.
My lord, my lord.
I am
can you-
asking.
Yes, yes, my lord.
So why you did not include them a party here in the appeal? Have you filed
My lord,
application
yes,
here?
my lord, our application was
Yes,
allowed
my lord,
and we
kindly
have
see
been
the
included.
can
Yeah.
4168.
Writ petition in this mandamus appeal, this application is taken out by you.
My lord, one by us, which was allowed pursuant thereto, my lord, we
Yeah.
were
In this appeal,
in this appeal only, my lord.
I am talking about trial court's application.
No,
Before
they
the,
similar person have filed also application before the appellate court also.
Similar person.
Similar
But
person.
they have already been added.
They have already been added, my lord.
So why?
No,
why
no,
you-
they have not been added. This application is still pending, my lord.
my lord,
Pending.
one application is pending,
4168. 4168. 4168 before the appellate court, my lord.
I am, sir, probably you have not seen. I have seen the impugned order.
My lord.
Let me be very, very clear.
My lord.
Why I asked this question. You have read the brief.
My lord.
I am talking about an order dated 24th of February 2020, which you are challenging
My lord.
in the instant appeal.
My lord.
Is it?
My lord.
In that order, I find that two applications have been disposed of at page 3. One is CAN 1047, another is CAN 1814. Means allowed.
My lord, 1047.
But we find that there is one addition application is also filed in the appeal.
My lord, kindly seize the cost title of 1047, CAN 1047 and CAN
have the
4168 are same. Parties are same.
1047 and
4168
are same.
same. My
So once they are added as a party, why they wanted to be added here also? It is your duty to implead them as a party. Why you did not implead them as a party?
My lord.
Application is allowed. Is it true?
Yes, ma'am.
Yes,
There is another application for addition of party.
my lord, the parties have been already added, my lord, subject to correction, my lord. Kindly cease, my lord.
Can 7, it is coming.
My lord, kindly cease, the parties have already been
Addition of party, whose application?
My lord,
Yours?
that is another my lord applicant. We have already been added in the appeal.
my lord, these persons have already been added.
Another
Applicants of
application
1047, subject to correction, my lord, have already been added in the appeal.
No different. I am talking about can 7 here.
Can 7.
This is also an application for addition.
Yes.
So they are the independent third party.
Can 7 to the can 7.
Fifty persons have filed this application for addition. Represent which? Orkodev Bishas. Anybody knows?
Orkodev Bishas chino.
Advocate also. Orkodev Bishas advocate. এটা হচ্ছে চন্দ্রচূড় চ্যাটার্জি। চন্দ্রচূড়, সরি, এটা হচ্ছে এটাকে
There is another application, can 9
My
for
lord.
addition.
My lord. And probably, my lord, there will be another can 10. Probably, my lord.
And this is by Mr. Gopa, I do not know, Miss Gopa Bisas. Care of Firdaus Samim.
Firdaus Samim was the earlier advocate on record of the appellants. Firdaus Samim was the earlier advocate on record of the appellants in the writ petition. In the writ petition. So these applications was filed in the writ petition.
Not in the writ
No, no,
petition.
no. Appeal or writ of it.
In this mandamus appeal.
Appeal কি করে করবে? তো চন্দ্রচূড় ফাইল করেছে।
Then another application can 10 at the behest of Hemanta Kumar Das.
My lord, may I take an inspection of the records?
My lord, this person
Inspection of the records, because all files have not come down to me. That is the
Don't worry.
that is the very
I have just gone through that. What are those applications?
My lord.
Out of 10 applications, I find 3 applications for early hearing, 4 applications.
my lord, my lord,
3 applications for addition of part
my lord.
7. 1 application for condonation of delay, 8. 1 application for stay of that memo of 23rd of December, 9. These are the 10 applications which have now come up before. You did not have to consult the record.
My lord.
Show me the record.
Writ petition. Page 1 to my lord, page paper
Are
book.
you a registered organization or not?
No, registered. My instruction says that it is a registered.
Where you have stated that you are a registered organization.
My lord, petition on what is a registered organization. My lord, page 7 of the paper book. Writ petition. Page 5, my lord, internal page 5, page 7 of the
Just
paper.
1 minute, for one reason I am asking.
My lord.
Be ready for a question. Be ready.
My lord, trying to be.
Writ petition is? Paper book is started with the affidavit in opposition.
My lord, the other paper book, if your lordship may kindly take. The other paper book which starts with the writ petition, my lord.
Where is that?
My lord, the other paper book.
Volume 1, volume 2 তো লেখা উচিত, এটা volume 2 হওয়া উচিত। কিন্তু আবার নতুন করে
আমাদের workshop থেকে আসে। ওগুলো আমার কাছে আসে। মক্কেল হারিয়ে ফেলেছে।
may I?
দাও নাই তো বেশ। দেখি।
আমি রেসপন্ডেন্ট নাম্বার 18 to 24.
মক্কেলের নাম কি?
আমার মক্কেলের নাম হচ্ছে রাজেশ মজুমদার হলো ফার্স্ট। রাজেশ মজুমদার হচ্ছে ফার্স্ট। রাজেশ
দেখি
মজুমদার
ছেড়ে দেখছি।
My lord, may I, since your lordship, who is Orkodev Bishwas, my lord, I was briefed in this matter, my lord, by Orkodev Bishwas. I preferred an application CAN 7 of 2020 because against us, my lord, they have prayed for termination. My lord, now I have to, whether I have not been contacted, if your lordship kindly, since your lordship called, said that if your lordship give me 1 day's time, I will take instruction and say whether I will be.
These applications can be disposed of.
Yes, my lord. CAN 7, because I am affected party, my lord. If their appeal is allowed, my lord,
The difficulty is, if we allow your addition, nothing will happen because this appeal arises from a refusal to pass an ad interim order.
yes.
Now, more than 5 years has elapsed or 4 years has elapsed. What is the consequences of the urgency in this regard? Let the writ petition
My lord,
where
I-
everything
Yes,
is there
yes,
be
yes.
decided.
Yes,
My
my
lord.
lord.
I was
Yes,
just hovering around
yes.
because I find there was one reference of Order 1 Rule 8 of the Code of Civil Procedure. And that means that this was really in the nature of a class action.
But my lord, only one thing.
Then I just thought that if it is the nature of a class action, then there is a difficulty on his part. But I find that the organization is a registered one. There is no difficulty. It can get sue in its name for the interest. So Order 1 Rule 8 will not be attracted. Otherwise, you have a problem. Its judgment of the division bench of this court says that unless that leave is granted, the suit is still born or the proceeding is still born and no injunction can be granted. So I was thinking in that line. What remains? Your purpose is lost. 23rd December 2020 order.
No, that is still in effect. That is still in
Can you
effect.
ask for a stay of the operation now after 4 years?
Not exactly 4 year, my lord. That is continuing. That memo is continuing.
It has to be 4 years. It has accrued a right. Now it is better to
Not to give any further effect, my lord. That would be my. I will
Lord,
be playing that.
Best of respect, it's not 4 years, it is 20 years, my lord. Why I tell you?
No, this
My lord, I tell your lordship only one.
petition
Yes, my lord, I
is
tell your lordship why 20 years.
not 20 years. We will go
My
by
lord.
that change. 4 years, let the writ petition be decided on merit, interim order refusal.
My lord.
No, not to
Purpose is
not no.
lost.
That will create further rights, my lord.
Whatever.
That will
the
be
writ
more
petition-
cumbersome, my lord. That will create further rights, my lord.
No, nothing.
Multiplicity proceedings will come up that
Nothing.
after. So not to give any further effect. That will be my prayer, my lord. My lord, may I place it on merit, my lord? My lord, may I place the merit of that? My lord, kindly seize the notification, my lord, once.
There has been, my lord, further modification of this notification in all these years, my lord. So, my lord, unless the other subsequent notifications are challenged, my lord.
Yes, my lord, this is not the parent notification. In 2005, my lord, only once, man.
They challenge a particular notification. Whether it is a parent or an ancillary or in furtherance of or in supersession of, will be decided in the
I'm grateful,
rectification.
I'm
Going-
grateful. I'm
My
grateful.
lord, kindly,
We will confine that this notification is challenged, whether this notification can be quashed or not.
My lord.
Beyond that, we can't go.
My lord.
Yes, my lord. My lord, my application may be allowed.
You go and make an application before the
My
trial
lord,
court.
that
Why
liberty,
will-
my lord.
Why will bother here?
Yes, my lord. And since I have made this
bother, yeah.
application, liberty may be given, my lord.
my lord, may I have an opportunity of 5 minutes, my lord? Only 5 minutes, my lord.
28, 5 minutes will take you to 34. 33, giving you 1 more minute. 5 minutes.
My lord. My lord, kindly see the notification once.
Page,
What the notification says,
page,
page 99, my lord.
yeah.
By way of this notification, services of the part-time teachers have been regularized in violation of the circulars of UGC, which cannot be done. My lord, even if I leave, my lord, 2 classes of teachers, part-time teachers, have been created by way of notification. One having UGC qualifications, named as SACT 1, and another group not having UGC qualifications, stating that teachers not having UGC qualifications will be grouped as SACT 2. My lord, kindly see paragraph 2. Part-time teachers, casual, whole-time teachers, and guest teachers don't having qualifications for appointed as teachers in the colleges as prescribed by the UGC, University Grants Commission, and as followed by the West Bengal College Service Commission on the date of issuance of this order, will be renamed as State Aided College Teacher Category 2 and will get a remuneration of rupees 20,000 per month. And their services have been also fixed. Their period of retirement has been also fixed at age 60. My lord, kindly sees the UGC notification once. Page 37, my lord, kindly sees. But it starts from page 37. My lord, I'm taking, since time is short, my lord, I'm taking just to the relevant page at page 40, my lord, kindly sees. My lord, kindly see, the last portion, paragraph B, my lord. Guest teachers may be appointed only against sanctioned posts. Such appointments should be kept to the barest minimum. Second, my lord, C, the qualification of guest part-time teachers should be the same as those prescribed for the regular teacher of the university. So UGC categorically, and time to time this notification has changed, has come, categorically states that even a guest teacher should have the qualification of a regular teacher. And my lord, kindly see page 47 once. This notification clearly says, no person shall be appointed. My lord, paragraph 2, my lord, qualification and service conditions. Page 47, my lord. Paragraph 3.1, my lord, 3.1. No person shall be appointed to a teaching post in the university or in any institution, including constituent or affiliated college, recognized under clause F of section 2 of the University Grants Commission 1956, or in an institution deemed to be a university under section 3 of the Act, in a subject if he or she does not fulfill the minimum qualification and other conditions of service as indicated in the notification. So even a guest lecturer should have the minimum qualification of a regular teacher. No, and the notification, this notification which is under challenge, clearly says in unequivocal words, the teachers who are not having qualification of regular teachers are grouped under SAC 2 and they will get a remuneration from the public exchequer.
Yes.
That is the crux of the matter, my lord. Can this notification, my lord, survive? Can this notification, I could put this question to myself, my lord, is this notification maintainable or can stand? Where this UGC guidelines are very specific. So if I have been able to make out a prima facie case, my lord, for the prima facie satisfaction of my lord's judicial concerns, my lord, I'm only humbly praying for a interim relief.
Several applications has There was one matter, we will be calling in seriatim. There was no representation on behalf of the state. The prayer in the appeal was very, very, very innocuous. The writ court has recorded that the board has already directed to conduct an inquiry. And on that basis, the writ court says that now nothing remains in the writ petition, dismissed. What he wanted is that once the court has recorded the inquiry is conducted, there must be a timeline within which the inquiry is to be completed. This is what he really wanted. Nobody was representing the state. We wanted you to be here so that we can dispose of the appeal unnecessarily. We can. What is that number?
Item number 31.
Who was representing the state? 31.
I had with him. He was here.
I'm for the headmaster.
He is for the.
We are not concerned with the headmaster now. So this is what we really wanted to dispose of. Nothing more.
But if your lordship permit, but certainly, my lord.
Yes. Give him a copy then. A copy.
No, just.
Hey, we are also dispose of.
Can two. Checks
Sir, against your client, there are serious allegations. Now, board has already undertaken for an inquiry. Inquiry will take its own course. It will be
The only thing is that what the allegations against me is that
is a misuse of the funds, school funds.
it is not really
Now you are denying. We are respecting that denial. Go deny that before the board inquiry.
in fact I had paid the entire money which was allegedly
that we don't know.
from my own pocket. That is their own
Look
statement.
at the order. There is already, you have not challenged the order.
No, I have not challenged the order.
So
The only thing it is there.
last paragraph of the first page.
Last time.
Mr. Ganguly Tata, Advocate, West Bengal Board of Education, the board being the disciplinary authority of the respondent number 8 has written data to the respondent number 3 on September 2023 to conduct an inquiry into the allegation of the petitioner against the respondent number 8 and to file a detailed report for the board. Reminder letter shall be issued to the respondent number 3 and the board, and after receipt of the report shall take appropriate steps. Copy of the letter is taken on record. The grievance of the petitioner has been addressed since the authority has.
This is what it says, that it has been addressed because the inquiry is directed, but there must be a timeline within which the inquiry to be conducted. That is what he wanted.
Nothing
The only thing, may I just submit this? The district, the DI has already given a detailed order in respect of this. In fact, I had paid.
It has been done.
I had paid the money
No,
from my
sir.
own pocket.
Has he given after September 22, 2023?
No, my lord.
That is
not
what
there,
is there. The board has said by letter, I have directed him to conduct an inquiry.
Absolutely. That
So anything done prior thereto will be of no consequence. So the board has taken up the responsibility.
The only thing, the problem is the rate petition does not
Happy
the board will not be influenced by this order. If one line,
They will not be.
if one line can be added,
No,
otherwise.
For abundant precaution, it is hereby made clear that
Item number 14.
My lord, in this matter, my lord's views were that read tentative. My lord, this is the second round of appeal. In the first round of appeal, my lord, the order of the appellate court,
for the respondent or appellant,
I'm the respondent.
the appellant start.
Yes, my lord, your lordships, I know, my lord, your lordship's memory never betrays your lordship. Your lordship, my lord, on the before vacation, Xmas vacation, my lord, where your lordships were minded to deliver a judgment condoning the delay, that what should be the procedure. While, my lord, dealing with an appeal where certified copy, my lord, despite
We have already delivered a judgment on that score.
in this matter,
My brother authored that judgment.
So, my lord, today,
23rd or 24th of December, the December.
and Kaushik Majumdar's case, my lord,
I do not know. Yeah, now.
এই মামলা
address my brother that what wrong he has committed in that judgment. The Salt Lake, what is this? Yes, I remember. Whether writ lie in relation to a service.
I have handed up a compilation of judgments and I have also
My
indicated
brother has also considered those. This is the judgment.
on 24th December.
Give it to him.
না আমি তা তুলে নিচ্ছি
Oh, I delivered. I believe my brother delivered.
No, your lordship.
Now tell me what wrong I
In
have.
fact, what the judgment delivered by this honorable this bench not precedes sentencing date.
I know. That's what I say.
Yes. Now, my lord, I do not know, my lord, the facts of this case, but still.
Fact is very clear. I am giving a school which is an unaided school has terminated its the teacher or a non-teaching staff. Let us take both. Very hypothetical case.
Yes.
Teacher or a non-teaching staff. The teacher or a non-teaching staff approached the writ court, assailing that order of termination. Then the question arose whether this school, which is an unaided school, is an authority within the meaning of Article 12 of the Constitution. If it is not, then no writ lies.
I understand.
Now, argument, I am telling you, the argument was advanced that education has a flavor of a public element or discharge of the public duty. So, it is not a hard and fast rule that he should come within the bracket of the authority in a very stricter sense. The logic is that if any person or any organization discharges the public duties, then in that event, he is amenable to a retribution, which we also held in our judgment, yes. But the fine distinction was made. Had it been an allegation in discharge of a solemn public duty by that particular educational organization vis-a-vis the public at large, then that concept of public duty may be involved. But if it concerns its termination or the service of their employees or a teacher or a non-teacher, then it comes within the realm of a private law. And once it comes within the private law, there is no involvement of a public element. And therefore, in such scenario, no writ lies. This is what I first time held in Narayana. Then the apex court also subsequently in St. Mary's held the same. Then there are in between judgments, then army welfare, then it's a last judgment. So you are.
Yes, but I will not buy that argument because after Ramakrishna Mission delivered by the then Chief Justice of India, that even if it is a public duty, it does not make my institution within the fold of Millet Article 12. I will not buy that argument because Millet, after this is law has been settled. It has to be a monopolistic nature. Ramakrishna Mission, Millet, your lordship has considered possibly.
Yes.
Nobody say that the law is settled. I think as of this date, it is settled.
I loosely, Millet, use this term. It is my inability. Now, Millet, so Millet, I will not buy that argument regarding this. I will show your lordship that this appeal, this second round of appeal, Millet, it's started its journey, Millet. If your lordship, Millet, kindly takes pain, Millet, to turn the page 70 of the petition, which states, Millet, that what was the consideration weighed with the Honorable Division Bench between the same parties when the issues were same.
Now, second question that really stuck in my mind. Sorry for interrupting.
No, Millet, I am.
At one point of time, the court entertains the litigation, but the courts inherently lack jurisdiction. Does it confer or whether that order remains binding on the subsequent bench, coordinate bench? That's the second aspect.
Lack of inherent jurisdiction.
There are three kinds of jurisdiction. If I understood correctly, correct me. One is the pecuniary jurisdiction. Another is the territorial jurisdiction. And third is the plenary jurisdiction, means the inherent jurisdiction in respect of a subject matter, which is an inherent jurisdiction. Inherent, inflexible. Otherwise, both are flexible. Territorial and pecuniary in view of section 21 of the Code of Civil Procedure. Flexible. Third. Inflexible.
Inflexible. Yes. So, Milord, these are the two questions. Now, Milord, if I take my lord's kind attention to Milord page 70 of your lordship's brief, what was Milord weighed with the division bench and what was Milord the decision? And if 101. Milord, this was against Milord the order of termination without any charge sheet. And Milord, even then, if your lordship says this was never the question in any of the decisions, Milord, subject to correction, Milord, before this honorable court, where Milord, a particular code framed by Milord the government, Milord, in pursuance of Milord Article 13 of the Constitution and also from list 25, item 25 of the list 3, schedule 7 of the Constitution. This is namely, Milord, Anglo-Indian School Code Regulation 2424A. This Anglo-Indian School Code Regulation, and Milord, this was an exercise of power, Milord, flows from Milord the particular entry list of the Constitution.
Seventh list.
Now, Milord, Milord, possibly as on date, the law is settled as on date, as your lordships observed, that Milord, in violation of any regulation, like Milord decided in Milord that cooperative societies case, where Milord Reed does not lie.
I understood.
And in none of the cases which has been passionately.
I have decided.
Yes. This is violation of regulation.
I have decided one.
Regulation.
Sir, yes, this is the case. Samim, Mr. Samim appeared.
Mr. Shamim, I did not go through it. Milord, just now, Mr. Mojumdar, my land.
He argues on that.
Milord, he argued on the West Bengal Settlement of Disputes Act.
Specified state act, and that provides certain things.
This is different, subject to correction.
This is a specified state act, if you say Anglo-Indian.
Anglo-Indian, Milord, I repeat at the cost of tiring repetition, this has a Milord, the term regulation, what Supreme Court has defined. If this regulation is
specified act.
It's a it's a code, my lord. Kindly
Regulation,
see.
whatever specified regulation.
Yes,
it's a
my lord,
delegated-
but
It's a delegated.
I said, my
legislation
lord,
of
I will show, my lord, the
no
judgment.
difficulty. That is there. They argues in this regard.
But this regulation, this particular regulation, my lord, this was, I may read for my lord.
No, not necessary. I'm aware of Anglo-Indian.
My lord.
I'm aware of that.
Oh, my lord, this says, my lord, that this is power in exercise of the power conferred by sub-regulation 2, regulation 1 of the Code of Regulation, Anglo-Indian Other Listed School 1993, published under Education Department number such and such. The governor is pleased to hereby appoint.
Mr. Samin was referring some other act. I'm telling you, this was there, which is a West Bengal administrative within bracket adjudication of school disputes commission act.
No, I'm not on that. I'm not on that.
He says that when this act is come, and this act provides a full mechanism which includes an unaided school as well, then in that event,
Will it
there
this
is no
protection?
difficulty in maintaining the writ petition.
No, I am not on that. Will it possibly I can make a distinguish facts, my lord, on law and facts, my lord, on this aspect.
The ratio has to be culled out. I have not come across in my career that two cases have identical facts. What the ratio is to be culled out in the facts of the case is that if this is the law which emerged on a core value of the statutory provision. Your contention is that there is a regulation or the code, or I do not know.
Unless I place this, my lord, how can I pursue?
Framed by a legislators in exercise of the constitutional powers which is conferred.
I have more to say, my lord. If your lordship says no.
This is also an act which was enacted by a state. This was also an act enacted by the state. And then it was sought to be contended like you, that since this is the statutory.
My lord, I have a different submission, my lord, if your lordship allows me. That no, my lord. No, Mr. Shami Mohammed's, my lord.
Impertinence in this.
No, my lord. No, my lord.
No, don't worry.
My lord, if my fate is decided, then I will not argue.
Because I wanted.
No. I have not gone through your lordship's judgment just now, my lord. I have got it.
It was indicated on the last occasion.
Forget about this judgment. You argue.
I will get only 4 to 5 judgments I will show.
And this judgment was tested by the Supreme Court.
But possibly this was not over. This is
Anglo-Indian is the first case on this Article 31, Article 29. This is Special Minority Linguistic Society, Educational Society. And then followed by the Frank Anthony, then followed by Frank Anthony.
Milord, entire court has not been declared ultravirus 24A proviso into virus.
Not.
State has a power and the source of power.
I'm saying we are not on the virus of this court. The legislature.
I am saying, Milord.
The legislatures have the power under the Constitution to enact. It's no difficulty.
Now, if that is so,
the impact of such enactment.
Yes, what is the impact? What is the yes?
Between teaching and non-teaching staff and the school.
Yes. That is my case.
Unaided
That is my case. Milord, if your lordship.
Forum to enforce.
No, there is no forum. No, that is Milord. That is Milord. I will come. That is there is no forum.
Forum.
No, that is why Milord.
Lordship, in respect of item 20, Lordship, item 22, I was seeking your Lordship's leave to correct the annexure. Unless that leave. Grateful.
Honor for the applicant. Pursuant to your Lordship's earlier direction, my lord, my learned senior friend for the commission, my lord, has used an report, an affidavit. I just wanted to use an exception to this. Well, I'll be taking only 2 days time for taking the exception and come back to your lordship.
Pursuant to the order dated 11/11/2024, the Central School Service Commission files an affidavit which is taken on record. The counsel for the appellant raised for a leave to file exception to the said affidavit. Let such an exception be filed within a week from date or 2 days. What?
Yes, within 2 days I can do. But, well, let it be a week.
Within a week from date. This the matter accordingly.
Gratefully. Gratefully.
If obliged.
Yes, the matter record.
Madam, now for the state, item number 26.
Nevertheless, point is very short, and I'm told your lordship had the occasion to deal with the same. The question is about getting the benefit of pension depends on the length of service. Here, there is a shortfall of length of service, and the rule permits the government may consider that. I am only praying that let this matter be referred to the Secretary of the Education Department, let them consider the matter if they find it's justified, and then pass necessary orders.
So what is how much is the shortfall?
Well, the shortfall is it's some like 4 years, some 5 years like this.
But they can make up the shortfall up to certain period.
No, now that has been settled by the court that if it's found that the appointment letters are issued delayed because of ministerial latches, that part can be considered. Therefore, this consideration may be left with the government, whether the court probably may not direct to do so. That's my point. I'm prompted by my junior that this honorable court was kind enough to condone even the delay of 5 years.
It's a delay of 5 years. Yes. There is a delay. How much days delay?
আমাদের কত ডিলে হয়েছে জিজ্ঞেস কতদিন শর্ট জজ সাহেব
সার্ভিসের শর্টফল এটা সার্ভিসের শর্টফল অফ সার্ভিস
কথাটা শুনে উত্তর দাও না আমার কত শর্ট হচ্ছে তোমাদের
যে এখানে সব করেছে একটা লিস্ট আউট করা আছে
I mean, a chart has been prepared, I find by my friend shows me, where the details are given. Some 2 years, so maximum is 8 years and 7 years, but others are 2 years, 3 years.
4 years, 6 years.
দেখি এই আপিল কোর্টে যে এসেছিল ওই অর্ডারের স্টেশন কোথায় আমরা না ওই যে বললি যে জজ সাহেব অ্যাপিলে ইন্টারফেয়ার করেনি আগে একটা ম্যাটারে
আমাদের অ্যাপিল কোর্টের অর্ডার
To us,
the rules. দেখি হিসাবে রুলসটা দাও না একটা দিয়ে হয় জজ সাহেব দিয়ে দাও তাহলে
what is this? Headmaster's manual or what?
Yes, headmaster's manual.
To us, which page? I don't know.
I don't know the position will vary. So for the edition is
This edition?
Yes. Well, page number.
Page 414.
Volume 1.
414. Volume 2.
Volume 1. Volume 2. Lord, I am having a spare copy. May I hand over?
Yeah.
আর কিন্তু কম্পেন 6 months কিন্তু কোর্ট went up to the 6 years যেটা হচ্ছে তারপর
সেই ওরা তো কোথায়
Volume 2 আছে?
হ্যাঁ আছে আছে my lord I am having another my lord I am giving
172
এই যে এটা আরেকটা দিয়ে my lord I am handing over another copy
What is that?
My lord, chapter 3, that under the heading service qualifying for pension.
Yes. Chapter 3.
Yes, Lord, regulation 7, service qualifying for pension. Well, got it.
Correct.
Yes. Now, Lord, Lordship need not be Lord, detained with the entire thing. Kindly come to Roman 4.
Roman
7E 4.
Yes.
Upon any condition which it may think fit to impose, government may condone a deficiency of 6 months in the qualifying service of the employees of non-government sponsored aided educational institutions.
So it's up
Now,
to
but this was considered by our court. In a case where 5 years delay was concerned, that is also a part of the proceeding. Kindly come to page 174.
one page.
Page 1, it starts from page 172. Aste, aste, aste. Shortcut করে জলটাকে দেখাতে হবে। Milord, in the internal page 5 of the said document, Mr. Rahman, land advocate appearing for the
From page 172.
my lord. Kindly turn to page 176, the internal page 5 of the order. Well, got it.
Yes.
Milord, the paragraph begins like this. Mr. Rahman at the top, land advocate appearing for the state respondent submits that the shortage of qualifying service of the petitioner is more than 5 years, and that the past unapproved service cannot be taken into consideration. After considering this, the Honorable Court says, Milord, at the bottom, the provision of the pension scheme confers jurisdiction upon the competent state authority to consider and condone the deficiency of qualifying service for the purpose of availing full pensionary benefits, and such authority as conferred by the state pension scheme cannot be scuttled by limiting the period of condonation, inasmuch as such restriction would lead to discrimination. Pension is a retirement benefit, I am not familiar with that. Therefore, the next page, upon hearing the submissions made on behalf of the respective parties and upon considering the materials on record, I find that discharge of service of the petitioner with effect from 8 November 71 does not stand disputed by the respondents, and in the DLIT report dated so leading to recognition of the said school, the petitioner's name features as teaching staff serving in the unrecognized school. And in the backdrop of such factual scenario, the period of service rendered by the petitioner, though in an unrecognized school, should not be altogether ignored and should be taken into consideration to make up the shortfall in computing the service for the purpose of granting benefit of usual pension and gratuity to the petitioner. A grant of pensionary relief to the retired persons was introduced by the government as a social benefit scheme, and when admittedly there is no dispute that the petitioner had rendered service since the year 71, the respondents cannot deny to condone the deficiency of qualifying service of the petitioner through grant of notional approval only for the purpose of disbursement of pensionary benefits. In the aforesaid circumstances, I direct the respondents.
Mr. Bhattacharya, this case as it appears from this finding is that the persons were really rendering their services in an unrecognized school.
As an organized teacher.
School was recognized. So there are a lot of claims that are coming before the court that the date of confirmation on approval should be from the date of recognition or from the date anterior thereto. So these questions often come before the court. Now, for the purpose of pensionary benefit, the single bench has said that since they were actually running, discharging their duties in an unorganized school or unrecognized school, which was later on recognized or approval was granted, then
consider
a
notional
beneficial piece of a legislation. You please take into account those, and the government was directed to do it. The division bench also considers in this way. Special petition was dismissed as it is done. No infant. Here is a case where the recruitment process was of the 2006. Interview was held in 2009 and the appointment was done in 2011. So it's the first time the initial or the appointment really initiated or ensued, I would say, from a date. Anterior date can it be taken into account? You were not rendering services. There's a
So
single
that-
bench judgment. You
But
you
that,
did not render.
the landed single judge my lord had committed.
You did not render services.
So
For that, this period cannot be
Blood
completed.
bolte dao. Landed judge was factually correct when say physically that I did not render service. My point is that you delayed in issuing the appointment letter. Though the Honorable Court directed issue appointment letter at a certain point of time, that delay caused because of your ministerial lapses. Now consider this delay, whether this is my part or not.
So when at the first day, when an appointment letter was given, and the appointment letter says that it will take effect from a particular date, can you not approach the court immediately saying that my notional benefit must be extended from a later point of time?
Could have.
It is only after the retirement
Could have.
you could have you came forward and say that this cannot. No.
The minors will.
You know from the core of your heart what is the fate of this matter.
It could have. Now, not only that's why I was submitting, Milord, if
You really wanted that, let the ball be rolled in their court, let them reject it.
no, let them consider.
Beneficial.
Let them consider whether these latches on the part of the ministerial functioning should deprive me of pension.
No.
That should be considered.
No. I can hold here.
Now you need not hold. That's why I'm asking.
I can hold here. And distinguishing this judgment of Justice Chakravarti.
I did not invite this court to hold it. I know that would be against me. That's I was
service jurisprudence.
I was only praying that if that should be considered by the government as the rule permits, if they feel is latches was because
we are saying that we are sending it with the remark that it will be rejected.
Lordship send it without any remark.
With the remark that it should be rejected.
It may be considered sympathetically. That's the prayer. Let us not waste time of the court.
Unnecessarily, Mr. Bhattacharya. It is an open and shut case. You know, the rule
But
gives
even
a
the-
relaxation of 6 months.
Let
If it is within 6 months, no, one case you will say 6 months, will direct. Here and now. We'll direct.
no. I find that there are many. Dates are different. Someone 2, someone 8.
They ranging. So I was just talking about ranging from 6 months to 5 years or 8 years. I'm just talking about that.
No, I follow. I have no hesitation to accept what has fallen from court. That I cannot, to be very frank. But at the same time that I will appeal, since the government is there, let them decide. If they decide,
Can they act contrary to their own statutory?
no, they cannot. But after because of the judgment of this court, the principle should be
what
taken.
I wanted to make a distinction that
Lordship,
this case and that case stands on a different footing.
my lord may be pleased to observe, but do not say it calls for dismissal.
But how can we issue any? Really, the Supreme Court in a recent time has deprecated the High Court for sending the matter for consider the representation.
No, that's also law. That if law doesn't permit, you cannot.
2024, the court has said that if you find that he has a right, decide it. If you do not find he has no right, if you do not find he has any right, dismiss it. Why you send the matter to the government?
I have nothing to add. Only
there are certain more facts are required, certain evidences are to be taken into account. These all depends upon certain things. Then I can understand we can bring it to the authorities, give them opportunity, let them file the documents, let him consider. But it is an open and shut case because it is all beyond 2 years. All beyond 2 years.
Just let him first not understand.
He has to be satisfied first. You have a very hilarious start.
With taking permission from my senior, I'm saying that primary teachers who was shortfall of service 2 years, 3 years, they got the benefit from the.
How can in derogation?
That has been
How
gifted.
can has been
That has been
derogation
gifted. I
with
can
the
show your
rules?
lordship. I can show your lordship. No. That was the order passed by the Secretary Education Department.
If they done, if
Primary teacher.
illegal,
Primary teacher.
please, then the law is, if suppose an illegality is done by the authority, does it confer any legally enforceable right on the others so that the government will go on doing the illegality? I am asking. if the mandamus can be issued in this regard, I am happiest person on that. I believe the happiest person on that. Mr. Bhattacharya knows better. He knows, but
ওই ক্ষেত্রে তো they had rendered service, তোমার ক্ষেত্রে সার্ভিস করোনি তুমি।
Another submission, but I don't know whether you will also accept it. Under the same council, under district primary school council, 4 petitions moved. One after another, the numbers are either before or after this matter. But all of them got order to consider by the secretary. So what same, same area, how they will think that.
come against those orders, I will take care of them.
No, that is our favor. That is in our favor. Well, I have got that order.
From where they derive a power to extend beyond 6 months? I am just asking.
No, they did not extend. What he says that Honorable Court directed them to consider.
In the
The,
same
the
area,
ultimate result might be same.
Yes.
But the only
You will direct them.
yes.
The rider,
Very well.
you cannot extend beyond 6 months.
Why not? No. Why not the under the same council, under the same
ওরা
area?
কি তোমার রিলিফটা দিয়েছে?
Yes, they are not yet.
Therefore,
But the matter
what
was
if
referred.
what he feels, Lord, that
The
let
same-
this
same
client
order
also have the satisfaction that this
Yes.
matter was referred to the council, the Secretary Department of Education, and he has considered and rejected. The considered rejection should from there, not here. That's the only satisfaction. there.
That's a good benefit for him. Next round.
No.
We will do it, but with the rider.
No, why not?
Don't
আরে
worry.
করবে
Do it with the rider.
দেবে না কনসিডার করছে তো কোর্ট পাঠিয়ে দেবে। So that's all, but I don't have to say anything.
Secretary school education.
তপন ঘুমোচ্ছিস খুব আনন্দে?
Did you file your opposition there in the trial court?
Malote, I am for the respondent counsel, and Malote, in the trial court, Malote, no opposition has been exchanged.
You also did not file your opposition.
No, my lord.
There was no position.
No.
Malote, I have there.
শান্ত হও, শান্ত হও।
My conscience is not for me.
No. If the judicial conscience stands in the way, what can I do? But your lordship may observe and then send it.
I know how to observe.
And
I know how to observe.
that's better.
He said.
Judge অবশ্যই বলবে।
সেটা না। হ্যাঁ।
আমি কি
Send
বলবো?
করতে গেলেও তাকে পোস্টটা ফাইন্ডিং দিতে হবে। এই
আমি তো স্টেট বলবো। স্টেট না, আমার তো কোনো পাওয়ারই নেই সরকার
সেক্রেটারি করবে। Primary, the 2 years, 3 years, they have complied with.
Look at it. All the case is that you rendered only 1 year to 5 years of service.
Yes.
Not beyond that.
No. Some of them only 2 years left, 3 years left, 8 are there within 5 years. 5 years they have service, 5 years not. Even 8 years done, 2 years left. So in this way, well, let him consider.
The grievance is that all the writ petitioners retired between the year 2011 and 2015.
Yes, ma'am. Yes.
So in that event, it is only 1 year to 4 or 5 years maximum. Because the appointment was on September 8, 2011.
11.
Yes.
I'm getting to
Well, you got a chart while showing that there are some.
জজ সাহেব সেটা বলছেন না।
Not all. Maximum shortage is 5 years to 2 years. That chart I have. Not follow service, not that 1 year, 2 years, 8 years. Not follow service, 5 years, 4 years are there. Not that all should be allowed.
এটাকে সেপারেট করতে হবে তো।
করেছি। এই তো এর হচ্ছে
সার্ভিস গিভেন।
সার্ভিস গিভেন, এই তো গিভেন লেফট হচ্ছে 2 বছর 9 মাস
হ্যাঁ।
2 দিন। এই লোকটার শর্টফল আছে এইটা 2 years 9 months 2 days।
আর এগুলো তো দেখছি
এগুলো দিয়েছে, রেন্ডার করেছে।
2 বছর সার্ভিস করেছে, যেগুলো সেগুলো রসায়নের পক্ষে দেওয়া মুশকিল।
না না, সে কিছু পুরোটাই দিচ্ছেন।
জানা যাচ্ছে না যে কতটা সার্ভিস করেছে।
এটা দিয়েও ছেড়ে দিক, সেও ভালো।
সেটাই তো আমি ইনভাইট করছিলাম, তুই তাকে গ্যারেজ করবে কেন?
না না, ঠিক আছে। ফ্যাকাল্টিটা আমরা করবো না বলে না। না না, এই সামনে অনেকগুলো আছে শর্ট, তবে 2 3 4 4 4 তবে আছে 2 3 4 4 5টা শর্ট, তবে 6টাই হবে। কতই যাক, কটা হয়?
এটা বলবো?
হ্যাঁ।
What? But what he now Miller instructs that the shortfall beyond 5 years may not be sent for consideration. Shortfall within 5 years may be considered. Well, I could persuade not to that extent. Shortfall Miller within 5 years is 1, 2, 3, 4, 5, 6, 7.
Can we take it on record? Or we should not take it on record?
Don't take it on record, just look at it. Don't take it on record.
Very
Same area, one set of people. But on the same area, one set of people will get an order, one set of people will not get an order.
I'm making observation in this regard.
No, no, that will affect them.
I will make an observation.
That will affect them.
That the illegality does not confer any inchoate right or legally enforceable right into another person.
Well, there's no negative equality.
We will pay only consideration by the secretary.
But if this document is taken on record, then problem.
Don't take it. Just, I said, look at it, don't take it on record.
What?
The chart also accepted by them, the chart.
Malota, only thing, Malota, if that,
Why you have allowed the others more than 6
Malota, the issue is that, Malota, I have no,
this? Why you have allowed the others? If this statement is correct, why you have allowed the others?
Malota, as what has fallen from my learned senior friend, that it was sent to the secretary and secretary has regularized. Malot, I am for the council. Whether, Malot, there is anything to that effect, Malot?
He's saying that the council is divorced from the state or a sovereign command or the control, independent, having no.
Malot, I have to take instruction to that effect.
You are one of the limb of the government. Council, the state has done, council has not done. What is this? Are you divorced from the council?
No, Malote, what I am submitting.
Instrumentality of the state.
Malote, I am bow down to your lordship observation, but
every time I find, Mr. Bhattacharya, I do not accept and approve that there should be a separate panel for the council and the state. It should be one.
Should be one. Because council is the
every time these kind of an arguments are advanced. I am council, I do not know, state has done. State will say, I will.
Malota, only thing that I am, Malota, beseeching your lordship
your
regard
in that scam matter is still hovering. All the agencies are making different affidavits, taking different stands.
My lord, regarding this particular issue, my lord, then I have to take instruction.
What is that?
Because they have not disclosed anything, my lord, of who are the person who are getting this kind of thing. My lord, I am only beseeching, my lord, that I intend to say before your lordship.
The solitary grievance raised in the writ petition by the writ petitioner appellant is denial of You wanted the Advocate General to appear for?
No.
Advocate General appearing for the state, my lord.
Director
I am
of pension
saying
file an appeal, state is a party respondents. But the
State and the Director of Pension and Provident Fund is the one.
also state.
No, but
One is an alter ego of another. What is the difference?
that is why
However,
one of
my lord,
the
the
former
issue needs to
respondent,
be
because state
decided
was a
any
party
day,
there,
your lordship, is
and
the
the
matter
appeal has
we are
been preferred
suffering.
by the.
We are the respondent petitioners, my lord, they are suffering unnecessarily.
We are ready, otherwise, but
Why
I do not
you
know.
wanted the Advocate General to be robbed in.
Advocate General, I do not know what he says. বলো তুমি কি
the
বলতে
landed
চাইছো?
Advocate General argued the petition.
Prompting you to say something.
No, my lord. Your lordship was communicating with my
My lord,
senior,
I
so
tell your lordship, large number of pensioner
He's
wants,
an petitioner.
large
Yes,
number
yes.
of pensioner wants to get interest on the delayed payment of gratuity. No, time
Lords,
is
let the matter hard, lords.
no.
We are ready to lords to argue the matter. Let the matter. The respondent is lords to Kai. I am
তুমি
not.
কি কনভে করছো বলো, তুমি কি বলতে
my lord,
চাইছো?
I am praying for a short time, my lord, so that my lord, the landed Advocate General address. my lord.
May I tell one thing, Lordship? My lord, kindly fix a date. Lordship, on that day, my lord, I think, my lord, we shall, because otherwise today I'm also ready. But since it's my lord, he convey from the Advocate General, so I cannot oppose it.
That is what I find Mr. Rajaram Banerjee.
Yes, Rajaram Banerjee is also there, my lord.
He said that our Advocate General will appear.
Yes, my lord. Advocate General will appear, my lord.
But lordship, only that lordship, give me a date, lordship. Otherwise, advocate
fix a
general,
date.
pick any day, lordship,
Well,
as per your lordship
think-
convenience.
What is the matter?
Matter, may I tell, Lordship? Matter is that, Lordship, kindly, my lord,
Just outlook.
yes, my lord need not go
Not
through
out.
it. Yes, my lord, may I tell? My lord, in 2013, a special bench was constituted for the purpose. The issue was that whether my lord, the retired teacher of the secondary schools, whether they are, my lord, they should be given a chance to opt for switch over from CPF to GPF.
For GPF
That
to
chance whether should be given or not in terms of the ROPA, in commensurate with that. Now, my lord, in 2013, the judgment was delivered by the special bench that the fresh option liberty is given, window should be open, fresh option be allowed to be given within a period fixed, within 3 months or 4 months, issue notification, and only for those who are willing to refund the employer's share of provident fund with interest. And with a rider that these petitioners for whom that special bench was constituted, these petitioners or class of petitioners, everybody, all those persons, they said that they forgone their right to get interest in respect of the payment of the arrear,
So the petitioners.
whatever be the date of their respective retirement.
Interest was waived.
Interest waived. Though that has been recorded, that interest waived. So if they, my lord, choose to, principal amount will be paid, and that will be also, my lord, upon refund of the employer's share of provident fund with interest.
What? Interest waived.
No, interest waived on the part of the, my lord, the state, my lord, the authority, that they are not, my lord, supposed to pay the interest. But when you enjoy the said sum, the employer's share, you have to refund it.
Switch over to GPF, that the government will not pay.
Government will not pay interest, but you have to pay the interest.
Only pension.
But that was the, my lord, the judgment of the special bench. Everybody accepted that and acted upon it. After that, my lord, again a special bench was constituted for another issue, that it should be that not from the date of refund, because the first special bench judgment in 2013 was that you are entitled to pension from the date of refund. Then again the issue cropped up that whether from the date of refund or irrespective of the date of refund, the moment one agreed to that and refunded the said sum, whether that will relates back to the respective date of retirement. So that issue again cropped up. Then
How can it crop up?
my lord,
When the special bench says from the date of the refund.
again the special bench before the
and same core strength, 3 judge.
again
Same.
same
How can it be
3
decided
judges.
by 3
My
judges?
lord,
But that is, my lord, the fact that again.
Special bench clarified that.
And I'm coming to that. But in any event, again, that matter, my lord, again, before the special bench. Now the special bench, my lord, clarified that in a particular, my lord, 2 or 3 paragraphs, that no, it should be from the date of retirement. It should be from the date of retirement, irrespective of the fact of the date of refund of the said money.
Then the adjustment was allowed.
Then, now, from the date of retirement and to the date of refund, then another 3 or 4 years then come. Suppose somebody retired in 2000.
That's why I say the adjustment was done or adjustment was not done.
No. Now,
if their entitlement to get a pension originates from the date of the superannuation.
Superannuation.
Certain amounts till the date of refund is
Has to be paid. Has to be paid.
And equally, they are required to pay the employer's contribution in order to switch over from CPF
They
to
have
PF.
no. So far the judgment of 2013, on the basis of 2013 special bench judgment, they refunded. They refunded and opted for pension, and on the basis of that special bench judgment, my lord, their pension started from the date of refund. But suppose, my lord, the date of refund is 2014, when the notification, and suppose retired in 2009.
They are entitled from 2009, the balance.
So now the second time when the special bench constituted, whether if the superannuation in 2009 and the refund was in 2014 and started 2014 pension, then from 2009 to 2014, this period, they are also entitled to. That clarification has been made. That clarification has been made in 2019.
Has to be.
That clarification made. Then, my lord, everybody accepted that. That clarification accepted that. In that special bench judgment also, my lord, it has been recorded therein that the writ petitioners, the class of writ petitioners, they have foregone their right to get interest at the initial stage in 2013. So in 2019, when that arrear pension was directed to be paid, here also, it did not, my lord, there was no order to, it will carry any interest. It will carry any interest, no. Now what happened, my lord, one after another writ petition filed before this honorable court, before the learned single judge, and praying that interest in respect of that particular, my lord, period, that arrear period, from the date of retirement to the date of refund. And, my lord, initially, my lord, when they claim for pension and interest, prayer was that pension and interest. Suppose, my lord, the special bench judgment in 2019 for that arrear payment. Still, suppose, my lord, that amount did not disburse or they have not applied for that because they have to again apply. In the meantime, my lord, one after another writ petition filed, and file says this is the special bench judgment. So I am entitled to that arrear pension. And another prayer is, my lord, that prayer with interest. Now, my lord, the writ petitions each and every allowed, directing the authority to pay the arrear pension, that particular. But so far the interest portion, my lord, remains silent. That means interest opted but rejected. Prayer was there, or prayer rejected. Now one matter, thereafter another matter came up, bunch of writ petitions. These bunch of writ petitions, my lord, the learned single judge, while disposing of the matter, with regard to the interest claim, now again they say they come for that interest portion. Now again, after that payment, everything completed, now they come and say, no, we are entitled to interest. So again, fresh writ petition filed. This is sometimes third writ petition by a single person. Everybody, this way. Now here, my lord, the bunch of writ petitions were taken up together, and a common judgment was rendered, delivered. My lord, the rejecting our contention of the state government, that first of all, my lord, the two issue, very simple two issue. One is res judicata. That in all earlier occasions, you prayed for interest, but the interest rejected. So you are not entitled to interest on that particular sum of arrear. You prayed and rejected, so res judicata in terms of section 11, the explanation 5 of CPC. Second thing is this, that when the special bench did not allow the interest in two occasions, once in 2013 and another is again in 2019, then whether a single judge can go into this and explain the state, my lord, the contour.
But general is required to be.
But my lord, state is a party, advocate general my lord, argued the matter, and that is why he said.
Some other benefit I can understand, but.
No, question is, my lord, the question is, my lord, if the ramification is, Lord, so kindly consider, this is not the one or two persons. Ramification is that the
entire country will suffer. That does not mean the law will get changed.
No, I'm not on
Law
that.
has to be changed
Yeah,
by
no, I'm not
by
that.
using
But these issues are to be heard before your lordship.
Lordship, any day. Law has to be changed by a legislative fiat. Lordship, any day. Tell me. Lordship, any 2 p.m. Lordship.
Kindly please.
Then Lordship, otherwise Lordship. Tell the date. Lordship. That is my bitter experience.
Wednesday. Next Wednesday.
Any day as per your lordship.
Except, my lord, may I tell, except Monday and Tuesday.
You keep me.
বৃহস্পতিবার এখন না ওদিন পিল থাকে
তুমি তার কি করে বলছো as per your lordship?
15 করো Wednesday.
পারবো না। আমি লর্ডশিপ
ওয়েডনেসডে করো
লর্ডশিপ as per your lordship করবে। Lordship, we are agree lordship. Lordship, we are agree lordship. We are the advocate general appears on behalf of the state. We agree as per your lordship. Now lordship, my learned friends. Monday, Tuesday, Monday is the lordship. Monday is the first. Let's if the lordship. I know the genetic defect of Monday lordship.
Monday টা করো।
Wednesday at 2 p.m. Wednesday at 2 p.m.
Whatever you say. Wednesday is the day for order 41. Wednesday is the day for order 41.
Order 41. Then Thursday at 2 p.m.
Thursday, Lords.
Thursday at 2 p.m.
Thursday at 2 p.m. Lords. Thursday. An accommodation is sought on behalf of the state that the London is the advocate in record, that's why I asked.
Yeah.
He has only those cases. Delayed payment of pensionary benefit.
Only see the last order. My lord's order.
Yes.
Order passed by lordship.
Just
detailed calculation. Calculation to point. Calculation, they need a instruction. Calculation. বলছে পাবে না জজ সাহেব বলেছে পাবে না কিভাবে করবে কে ডিআই করবে না কে করতে বুঝতে পারছে না ডিবিবি এসেছিল তো বললো আমাদের ভাই ডিআই করে কিনতে পাঠিয়েছে
Oh, yes. Only thing is, shows the provision.
Provision.
We have already indicated
Yes,
paragraph 23(2).
Yes. Well, kindly see 23(2).
Please show us that. This annexed.
No.
From where I got that?
May I hand over a copy? Just your lordship dealing with that. Now, dealing with where? Because Ranjan Bhattacharya was appearing in the matter. Death term retirement benefit rules.
Yes.
1981. That is a scheme framed under Article 162.
Give another copy.
Yes. You need copy, the active copy, please. Active copy means. বই না বই আছে ওখানে That was amended in 2008. Instruction উপরে চলে দিন
In the year 2007.
No, 2008.
Amended in the
3rd July 2008. বই কোথায় এই দুটো জজ সাহেব বই আনতে হবে এবং বই না শর্ট টাইম না তখন পেন নিতে গেল
What is that? Headmaster's manual. Show us the date from here. Volume 2 or volume 1?
Volume 2.
Volume 2.
দিয়ে দাও বার করে দিদি
পেজ বার করো 470 এটাই 470
Page 471.
এবার আপনারটা রিটার্ন ব্যাক করবেন তাহলে পড়তে সুবিধা রিটার্ন ব্যাক করবেন এটা জজ সাহেবকে দিয়ে
সেকেন্ড ওয়ার্ড
রিটার্ন ব্যাক হলে তো পড়ে দেওয়া হবে এই দুইটা
Yes. Subparagraph 2 is now
amended,
modified. 2008.
2008.
At least 1 year of service is already there. He has rendered 1 year of service. So family pension is admissible.
Can you see the paragraph 32?
What?
Paragraph 32, subparagraph 2. 23, subparagraph 2. The benefit shall also be admissible in case of a death of an employee after retirement if at the time of death he was in receipt of any compensation, invalid, retiring or superannuation.
Or gratuity.
Or gratuity.
So gratuity is also given. So he says that he received gratuity. That is what we recorded.
Yeah.
And every word is disjunctive or comma is used.
And pension payment order also was issued, my lord.
No, pension payment order was issued because if somebody does not get the pension, then he will get the double gratuity.
Double gratuity.
Double gratuity.
So it was issued but could not be disbursed.
No, family
before
pension
that
was
he
granted.
died.
Family pension was granted.
Then?
At the rate of 1300 per month.
Then?
Now they are coming before the honorable. They have come. Their justification is that no, because the section 23(2) has been amended, so that pension payment order cannot be given effect to. But my lord, if you lordship kindly take up page 66 of my application. My finance department has clarified that retired prior to 37/2007.
What?
My lord, kindly refer to seeking clarification. Memo dated 26th May 2008, my lord.
Page?
Page, my lord, 66.
66 is
P11.
Careful.
2005.
Page
Yes, ma'am. Page 66. Yes, ma'am. Date 26th May 2008.
Yes.
The specific employee who received gratuity as retirement benefit and retired prior to 30th July would not come under the purview of this notification.
So he retired.
Retired in the year 2005.
2005.
2005.
30th April 2005.
So prior to.
Prior to.
So it is come and
Yes.
gratuity he received.
No, what can see the language of paragraph 23.
What is it? To be specific. To be specific, that is what is a more clarificatory. It should be comma. To be specific, comma. Employee who received gratuity as retirement benefit and retired prior to 30th July 2007.
Date of amendment,
Not come under the purview of the notification means what?
That is the amendment.
So it was given a prospective effect or from a retroactive effect, not from
1981.
prospective.
Not from 1981.
Retrospective, no.
No.
What more?
What is the law? That will be decided by a lordship.
No, this is your own act. Can you take a different stand than what you have said? Is correct. You brought an amendment by virtue of this.
3rd July 2008.
Correct. And there was a notification on 30th July 2007. And this 3rd July 2008 also does not take away their right.
But nobody has challenged the notification.
Not
My lord.
necessarily. He is
37,
taking a benefit of that notification. So why will challenge? He is a beneficiary.
But can I see the language?
Please.
For the existing entry in subpara 2 or para 32, there is a benefit also be admissible in case of a death of an employee after retirement. If at the time of death he was receipt of any compensation, invalid or retirement pension or gratuity.
Correct. So, or what is there? Pension or gratuity?
Whether it should be disjunctive or conjunctive, it is up.
No, it is a disjunctive. Whenever it is there.
Substitute the following entry.
What? What substitute the following entry? What?
The benefit also be admissible in case of a death after retirement. If at the time of death of retired employee was in receipt of compensation, invalid or retiring or superannuation pension.
Correct.
But he was not getting compensation or invalid or retiring.
No, he was getting a gratuity. He got the gratuity. You cannot deny.
But if somebody died, then automatically he will get the death gratuity. Death gratuity,
Sir, this is why you wanted to include this. I was also at one point of time I was also very surprised when you talk about under the DCRB rules allowing for the qualifying service to get the pension. You say 10 years.
10 years.
And here you say, I will give you a family pension, provided your husband or a father, he has rendered 1 year of service. Is it not a I think, inconsistent. The law, the person who rendered services,
And
he's not entitled to pension.
pension after until
But a
unless he gets
person who died,
Ah.
if he has rendered only 1 year service, then the family.
No, can you consider? If he does not, sorry.
It is not died.
Apart from a compassionate is the different family pension plus compassionate appointment, both. So he's benefited, family is benefited twice.
If somebody does not qualify for 10 years service, he will not get the pension.
And moreover, my lord, paragraph
And
1 is
you have already just now dictated the order. Just now dictated the order.
True.
But when somebody died without getting.
Sir, just imagine a person who served, what I'm saying,